Good afternoon, everyone, and welcome to the first webinar series of Cheuvreux in English. Cheuvreux Notaires, situated in Paris, decided indeed to launch a series of webinars in English for our international clients and partners that have business with France. Webinars will be dedicated to property in France, but not only. Throughout the year, further webinars will have to deal with various questions of family law, business law, taxation in France and in Europe. At the end of each webinar, we should have the time opportunity for live questions that each speaker could try to answer. However, if we do not have enough time, you can still email us your questions and it would be a pleasure for us to answer. Today, I will introduce you a basic topic about the property process in France. As a practicing lawyer at Cheuvreux, I decided to choose the topics I know from my personal and professional experiences spent in the UK and the US, that there are thousands of foreign persons investing in residential properties in France every year. And when you or one of your clients is unfamiliar with a legal system, buying a property might become a stressful situation. The process of buying a property in France is indeed highly regulated, with its own actors and follow a specific scheme. The first step is a natural step, is to find a property. There is a multitude of French or international websites that suggest properties for sale in France. However, make sure that these websites are managed by the estate agencies or notaries. Indeed, estate agencies should hold an accredited card called carte professionnelle to negotiate such properties transactions. As soon as you have found a property, please carefully visit the property with the estate agent or directly with the vendor and take the opportunity to ask all the questions related to the construction of the property, the state of the property, even the neighborhood, because all that points that seem important to you may be included in the purchase contract. As soon as you have agreed with the vendor on the property and the price, under French law, the deal is made. The offer is countersigned by the vendor. Then comes the time of the legal process, the time to sign a pre-agreement contract. There are two different pre-agreement contract types in France, called promesse de vente or compromis de vente. In the promesse de vente, the owner undertakes to sell to the potential buyer his or her property at a given price. The seller, therefore, gives the buyer an exclusive option for a limited period of time, generally that varies between 2 or 3 months. During this time period, the seller is prohibited from canceling the sale or offering the property to another buyer. The potential buyer can use the promise to decide whether or not he wishes to buy, which is a real advantage. In exchange, the potential buyer pays the seller a security deposit, which is usually 10% of the selling price. If the potential buyer decides to proceed with the purchase, the deposit is deducted from the total price to be paid. But if the potential buyer withdraws either her offer or fails to accept within the option period, then the owner retains the deposit as a compensation. In the compromis de vente, the seller and buyer both agree to conclude the sale at a jointly determined price. In legal terms, the preliminary sale agreement, therefore, has the status of a final sale. If either party cancels the sales, the other may take legal action and claim damages. The buyer pays between 5 and 10% of the selling price on the signing of the preliminary sale agreement. The sum known as a deposit is deducted from the price when the notarized instrument is signed. However, you can negotiate this deposit. It could be a non-deposit. Regarding documents to collect, the vendor should disclose all the information about the property, and that's the rule. In both situations, whether you sign a promesse de vente or a compromis de vente, the signature of the pre-agreement contract is subject to the collection of several legal documents. Of course, a copy of the title of property is needed. The seller must, for example, inform the buyer of the existence of easements or mortgage. If the property is included in a co-owner association, a copy of the co-ownership regulation is required, and the seller must inform about the state of the co-ownership association whether the other co-owners pay their core property charges. There are other documents to provide. The seller must also give to the buyer a certain number of surveys, like termites, lead, asbestos, electricity, gas installations, energy, the existence of any natural or industrial risk in the area, septic tank, polluting activities carried out in the area. There are the regulated surveys that the seller should provide to a buyer. If you need to get more information related to the building survey, therefore you should get your own survey. Because think one thing, you are buying the property in its existing state. Unless negotiated with a vendor, you or your client, as a buyer, cannot request from the seller to change building equipment or to repair part of it. The purchaser, the buyer, will accept the property sold in the condition in which they are found on the day possession is taken, with no guarantee on the part of the seller on any grounds like the condition of the land, the condition of the property sold, or the building to which they belong, defects of any kind, hidden or visible, which may affect them. Suspensive conditions. The buyer and the seller may agree to include some suspensive conditions. What are they? These conditions enable to the pre-agreement contract to be cancelled if certain events related to both parties occur before the final sale. For instance, the agreement may be cancelled if the buyer's bank refuses to grant a loan or if municipal authorities exercise their right of preemption. Under these circumstances, the sums paid the buyer are refunded. To secure the transaction, pay a deposit. To secure the agreement, usually a deposit of 10% of the purchasing price is paid by the buyer at the time of the pre-agreement contract. The sum may be negotiated to 5% or none. The deposit is directly paid to the notaire, who opens a kind of escrow account, especially for the sale. If you withdraw during the 10 days cooling-off period, the deposit is paid back to you. If you withdraw later than the 10 days cooling-off period with no reason, then the deposit is payable to the seller, who may also take legal proceedings for additional damages. Conversely, if you go through the process of the purchase, which we hope, the deposit is deducted from the purchase price as part of it. Finally, if completion is subject to one or more conditions which are not realized, then the buyer is entitled to a full refund on the deposit. And the law requires that the deposit is returned within the 21 days. The protection of the buyer. Here is one point under French law that is really important. It's a 10 days cooling-off period. After signing the pre-agreement contract, you receive a copy of the contract by mail or email, and then the following day starts the 10 days cooling-off period. During that time, only the buyer has the option to withdraw from the contract with no reason. These 10 days have been regulated in the property buying process in order to protect buyers from compulsive buying disorder. During the time of the pre-agreement contract and completion between, usually this is the time for the vendor to contact the banks and to find a mortgage. The vendor on its side is not allowed during that time to change anything in the property. But the major role played during this time is the role of the notaire. Who is a notaire? What role plays a notaire in the property buying process? In France, a notaire is not a notary public, known in most common law countries. In France, a notaire should be translated like a civil law notary, that is to say, a lawyer first, with a high level of legal education. At least 7 years of legal education are needed to be appointed as a notaire in France. A notaire, legally speaking, is a public officer who acts on behalf of his client and who drew up authentic deeds by affixing a seal and signature. Such deeds have the same legal status as a judgment. He owns the specificity from the state since he also collects taxes in the name of the state of France. A notary acts in different areas of law. In France, he has a monopoly of drafting property transactions, but he also acts on other various areas of law, such like family law or dealing with succession, wills, marriage contracts. He also deals with business law and company law. He is a lawyer first, as I explained, so a notary can advise you or your clients as regards to everyday life legal matters. As you understand, the notary is the main actor of the property buying process. He will collect all the legal documents that are required for the property transactions. He will check if all the rights of preemption have been observed and check all the financial consequences of the transaction in order to secure the agreement. At the time of completion, the notary will require you to wire what we call in French les frais de notaire. In fact, and usually speaking, notary's fees also include the tax attached to the property transaction. Since a notary is a legal or regulated profession, notary's fees in most of reality's practice are also regulated. A decree is available online to get all the notary's fees rates. But apart from the regulated fees, a notary may request non-regulated fees for every advice that do not belong to the deed itself, like legal consultation on which ownership structure when buying a property in France, or drafting a will in France, or taxation in France, or international estate planning with France. 3 months later, time to complete. Usually it takes 3 months after the signature of the pre-agreement contract, and when all the conditions are fulfilled, the notary will make an appointment to sign the final sale. The completion will be signed at the notary's office. Currently, notaries are not allowed to sign out of France. Therefore, if you are unable to make it, a notary may draft you or for your clients a power of attorney in order to sign the final sale. Before signing the power of attorney, please request a draft of the deed of sale to understand the ins and outs of the contract. As regard to the language of the contracts, all notarial deeds should be written in French. Thus, if you do not understand French, an interpreter of your choice must assist you at a meeting, or a translated version of the contract should be forwarded to you before the signature. The notary will have to ensure you that, or your clients, that you absolutely understand any single word of the contract. On the day of completion, you pay the purchase price and the notary's fees, which mostly include transfer tax. The money is directly wired to the notary, who, after signing the deed with you, pay the vendor after having paid co-owner association or other expenses by which the vendor is liable for. The notary also collects the tax and pays it to the tax office directly on your behalf. After the signature, then you get the keys. As you can listen, the buying property process is quite long in France due to a high regulation that protects both buyers and sellers, but also over external factors like the municipality, the environment, the neighborhood, in order to give legal certainty to the different actors of the property, for the reason that property is an absolute right in France. As soon as you are the owner of the French property, you are liable to pay some taxes attached to your new asset as well. As I explained earlier, at the time of completion, you pay a transfer tax, which is about 7% of the purchase price. These taxes are directly paid to the state, but also to the municipality by the notary. But then you are liable to pay the property tax and the dwelling tax. The property tax is paid by the owner of the property, while the dwelling tax is paid by the occupier on January 1st. Maybe you, or it may be the tenant if the property is rented. Even if you are not a resident of France, a non-resident for tax purpose, you may be liable for wealth tax in France when the property value is higher than 1,300,000 euros. Finally, if you resell the property, you or your client may also be liable to pay capital gain tax. The notaire, again, is the main legal professional to advise you on such tax issues. This short introduction on the property buying process in France aims to explain the different steps and the central place of the notaire play into property transactions. There are, of course, numerous surrounding questions about property in France, like which ownership structure to consider while thinking about property in France, how to finance a property in France, what are the marital consequences of holding assets in France, what are the consequences as regard to my future succession, what are the different estate planning tools provided by French or European or international law. This would be a pleasure for Cheuvreux to introduce in the coming weeks such of these legal issues. Before the chat begins, let me inform you that our next webinar in English will be held by Marianne Lefloc, notaire at Cheuvreux. Marianne will introduce you a commercial and office property investment in France. Marianne will speak to you in live from Cannes, south of France, where Marianne will attend there the meeting, which is the famous world's property market that should be in between March 14th and March 17th. Please keep tuned. We have a few minutes left, so please do not hesitate to ask your question. You can write your question in French or English, doesn't matter, and I'm going to try to answer the way you want. Thank you, Jeremy. Okay, do you have questions? If you do not have question right now, you can email me any question regarding the buying process in France. So you're going to find my email on the last slide of the webinar presentation. This is a.devaux@cheuvreux.fr. Do not hesitate. We welcome your questions, and it's going to be a pleasure for us to answer. Okay, so thank you for listening to me, and see you at the next webinar. Bye.